Hi, my name is Loren Locke. I'm an immigration attorney in Atlanta, and I'm talking about STEM OPT. What do employers need to know as they decide whether to give an offer to a candidate who says they'll have STEM OPT work authorization, or what do they need to know if they already have an employee who has OPT work authorization, but they want to transition to STEM work authorization? So, first of all, international students who graduate in the US often are given a short term of work authorization for them to try out working in a job related to their field of study. There aren't too many rules on the OPT period, which is generally the first 1 year out of school, but the second and third year are available only to people with a qualifying degree in science, technology, engineering, or math. And there are more rules for the job that they can do. There is more oversight and um, things employer needs to take into account. So, look, I get this question a lot. Do I have to do it? If they work for me already and they have OPT, do I have to do STEM OPT for them? No, you don't. You're not required to participate. And in fact, participating as an employer does have responsibilities. You have to be an A-Verify employer, not just for that one worker, but for the whole company. So that's something that some companies aren't willing to do if state law doesn't already make them do it or they don't already do it anyway. Secondly, there is a paperwork side. It's the I-983 training plan. Now, this one doesn't stress me out as an immigration attorney because it's actually prepared and just left on file at the school where the employee graduated from under the care of their DSO. That's the designated school official. It's available for the government to inspect. I have not seen the DSOs reject the training plan as inadequate. If anything, they would say, hey, it's not filled out all the way. Something's wrong with it. Can you fix it? Rather than, we officially assessed it and it's denied. I've never seen it get denied like that. It doesn't have a filing fee. It's not getting filed with a government agency. It's being kept on file during the period of work authorization. So what's in the training plan? Well, point of the training plan is to outline how the job offer is related to what that graduate studied and what is the point of the job. What are they going to learn at the job that is going to further their studies? And it has a little performance evaluation section, and it's got to be signed off by somebody, by the student, the graduate, and somebody at the job to show that this employee was overseen and supervised. So lots of different employers can have a STEM OPT worker. It's not suitable for somebody who's not going to be a true employee or not going to have an employer-employee relationship. So if you're a staffing company and you want to send your STEM OPT worker off to a client site to work outside of the supervision of your own company, that's not going to work for STEM OPT. If the worker's going to be in the office supervised by another employee, that could be really great. The pay rules for STEM OPT are not as rigid as they are for H-1B, but they are supposed to be paid commensurate with similarly situated U.S. colleagues. So you don't have to do like a labor condition application like you would for an H-1B. You don't have to look at what the wage levels are in your metropolitan area, but they should be getting paid what others who don't have STEM OPT would be getting paid for that job. The job needs to be at least 20 hours a week, and it's not supposed to replace a U.S. worker. It's supposed to be like supplementary to your U.S. workforce. A STEM OPT employer does have a reporting obligation, so if there's a material change, you do have to report it back to the DSO at their school, and if you terminate them, you've got to report it back. And that's actually even more important for the worker than it is for the company because that worker's got to maintain their F1 student status by showing that they are working in accordance with their work authorization after they graduate. If they stop working and they surpass the grace period, then they cannot hang on to that student status anymore. There is also the possibility that DHS could send an inspector to do a site visit of the work site of your STEM OPT employee. That's not been something we've seen a lot in recent years, but it is something to keep in mind that it could increase with the new Trump administration coming in. And then finally, it's really important to have clear and open communication with your employee and to consider in advance what's the next step. STEM OPT only lasts for 2 years. You can't just extend it. At the end, your employee will not have work authorization unless they get it somehow. A really typical path is that they would seek to move on to H-1B status. So that would require that the employer put them into the H-1B lottery each year. I'm going to do another video about that because the H-1B lottery is its own whole thing. So thank you.